Part 4 of the Sean Williams story in Johnson City, Tennessee, and we're going to start getting into some possible police cover-up and really bad botched investigations. We're also finally going to see indictments for charges other than the possession of ammo and drug possession. So we are on July 31st, 2023. Sean Williams' court motion shows Johnson City Police Department suspected he destroyed video evidence after woman's near-fatal fall from window. The Johnson City Police thought downtown business owner Sean Williams might have destroyed video evidence incriminating him or someone else in the near-fatal fall of a woman from his fifth-floor apartment window in September 2020. Michaela Evans' fall from Williams' window, which sparked a series of lawsuits and criminal charges that has rocked the city's police department, was initially investigated as a potential attempted homicide. Police interviewed Williams 2 hours after the fall, where they seized his phone and conducted 2 searches of his residence over the next few days. Those new court filings also revealed police knew that Williams had videos that he accessed from his surveillance cameras, and the investigators believed there were likely more videos that could determine whether Evans fell on accident or a crime occurred. The attempted homicide label is in a search warrant filed by Johnson City Police Department Detective Thomas Sparks. We've heard that name before. It's been alleged that Thomas Sparks discourages victims from coming forward and filing reports. The search warrant filed by Detective Thomas Sparks at 8:52 a.m. on September 19, 2020, barely 6 hours after Evans fell. Williams eventually was indicted for being a felon in possession of ammunition, then spent nearly 2 years as a fugitive. His appointed attorney in that case has filed a motion to suppress the first of 2 search warrants and essentially throw out his indictment. Significant new details about the hours and days after Evans' fall are revealed in Bryce McKenzie's July 14th motion and federal prosecutor Megan Gomez's answer, which was filed late Friday. McKenzie's motion essentially asked Judge Clifton Corker to throw out the ammunition case against Williams. Now remember, Megan Gomez is who replaced Kateri Dahl. It claims a search warrant issued hours after the fall lacked probable cause, that police, quote, illegally seized evidence, his phone, during an initial interview with Williams, and that the warrant should be suppressed and, quote, the indictment should be dismissed. The motion cites a News Channel 11 story from September 21st, 2020, in which JCPD's Don Shepard told a reporter the department didn't suspect foul play and was treating the fall as a medical investigation, calling it, quote, puzzling. Shepard's comments do appear to conflict with the affidavit Sparks filed on September 23rd, seeking a warrant to search Williams' safe. That affidavit claims probable cause to believe that Williams' safe is in the possession of certain evidence of a crime, to wit, and then ... attempted criminal homicide. Gomez's answer, filed late Friday, claims the JCPD acted properly when it interviewed Williams and seized his phone less than 2 hours after Evans was found on the sidewalk beneath his apartment at 2:30 in the morning. Gomez claims the initial warrant to search Williams' apartment and seize video cameras, storage devices, and related electronics was proper. And she claims the September 23, 2020 warrant to search Williams' safe, where they found 257 rounds of ammunition, was proper as well. Whatever Judge Corker may or may not rule on McKenzie's motion, Gomez's answer, and the attached affidavits and JCPD material provide new insight into the early hours and days of an investigation that so far has launched a cascade of other legal and criminal events. Among those, Williams' evasion of the May 5th, 2021 effort by JCP to serve the weapons warrant, and his subsequent fugitive status, JCPD's late 2021 decision not to renew a contract that housed federal prosecutor Kateri Dahl at JCPD to help prosecute federal drug, sex, and weapons cases. Dahl had gotten the indictment of Williams in April 2021, but had pressed JCPD to more aggressively investigate R-word and drug dealing allegations against Williams. 3. Dahl's June 2022 federal civil lawsuit charging retaliatory discharge and related U.S. Department of Justice whistleblower complaints. 4. Williams' late April 2023 arrest on felony drug charges in Jackson County, North Carolina, and subsequent transfer to federal authorities. And 5. A June 2023 federal civil lawsuit against Johnson City and several police officers on behalf of 9 alleged victims of Sean Williams, which we looked at in Part 3. The motion may also continue to keep alive the questions in Evans' mind, expressed during 2 interviews with News Channel 11, about whether she fell or she was pushed. She remains physically impacted by the fall, which left her hospitalized for weeks. It focuses mostly on Williams' interview at JCPD headquarters around 4 a.m. September 19, 2020, and the following few days. Mackenzie's motion claims Williams went voluntarily to JCPD, but became concerned when Detective Justin Jenkins called his apartment a crime scene. It says at that point, Williams wanted his lawyer, Jim Bowman, present, but couldn't reach him. With Williams allegedly locked in an interview room, Sparks entered. And upon learning that Mr. Williams wanted a lawyer, he reached out and grabbed Mr. Williams' phone from his hands and attempted to view the phone without consent or warrant. Williams eventually left and walked home without his phone. Sparks' affidavit for the first search warrant to search the apartment for cameras and related equipment says after powering the phone on, quote, it had a message displaying that it was lost, which would suggest that Sean Williams has access to other devices in the residence that could be connected to the camera system. Mackenzie claims the initial search warrant was a bare-bones warrant that lacked probable cause. It says JCPD violated Williams' Fourth Amendment rights when it obtained evidence from a seized phone, and it claims JCPD's seizure of Williams' safe, they held it until the second search warrant was issued 2 days later, wasn't allowed by the limitations of the initial search warrant. And don't forget, you guys, with the application of these warrants, when Kateri Dahl had first applied for them, it was granted and then it was sat on for a long time. It went past the 30-day window. I believe it was 30 days, maybe it's 31. It went past that window and she had to reapply for the warrant. So at the same time here, this defense attorney could be raising a great point that these warrants in and of themselves were flawed. And I wouldn't be surprised to find out that they were, based on what we've learned about JCPD, their handling of this whole thing from the beginning. And that would be a great example of how things that are incomplete, things that aren't done by procedure, that can get in the way of pursuing justice against someone that otherwise could be found proven guilty beyond a reasonable doubt with all the correct pieces in place. But if that integrity isn't there from the start, this is what we run into. So Gomez's response claims that the JCPD acted properly throughout the process. It notes that when investigators were in Williams' apartment before he went to the station, they noted that there were 2 video cameras that were directed towards the window that Evans fell from. Gomez wrote that investigators asked Williams about his surveillance cameras and that he stated that the cameras did not record anything on September 19th, 2020. He did, however, show Sparks 2 clips from other cameras of the outside and inside entrances to the apartment, which showed Evans, Williams, and another man enter the residence. At the station, following some back and forth about a statement or an interview Williams had refused, investigator Sparks seized the defendant's cell phone and informed him he was getting a search warrant for its contents. Sparks and Williams then argue over Sparks' right to seize the phone, Gomez writes. Shortly after, Williams leaves without his phone, which had gone dead after he had made a couple of calls. Gomez's answer reveals that by the time Williams' phone had sufficient battery, he had since walked home. It displayed a message displaying that the phone was lost when police turned it on. And so again, at this time, he had already sold the apartment that he had in this building, but he was up on this 5th floor. So imagine that fall. Investigators believe that the phone had been purposely wiped of the phone data, Gomez wrote. This left them unable to place it in airplane mode, and the contents of the phone were lost. The investigators concluded that the phone could have been erased by the defendant, and because of this, it was likely that he had access to other devices that could be connected to the camera system and his phone. The Johnson City Police Department never did get a search warrant for the deleted phone, but according to Gomez, their first search of the apartment yielded cameras that had been hidden in a closet. Officers also found a baggie of what was suspected to be cocaine, a gun holster that contained a handgun magazine, and the gun safe. According to Gomez's answer to the motion, officers asked Williams to open the safe, and that then, in his lawyer's presence, he gave officers the safe combination and said he had provided it under duress. After getting the search warrant for the safe, officers found 257 rounds of ammunition, something Williams couldn't legally possess due to a 1994 felony conviction for manufacture of marijuana in Jackson County, North Carolina. Gomez argues the first warrant was supported by probable cause, saying a reasonable person could infer a crime may have been committed, as it is not a common occurrence for a person to fall out of a 5th-story window. Suspicion was aroused, she writes, because Williams stated that the 2 cameras aimed towards the window that Evans fell from did not record anything, but he was able to provide 2 clips of cameras from before and after the fall. Based on the information they had obtained, Gomez writes, investigators believed there were likely more videos that could determine whether Evans fell on accident. Gomez also argues that Williams was not detained, but was at the station voluntarily the entire time he was there. And she writes that Williams' phone was critical to the investigation because it contained video surveillance of the incident. Only after the defendant and the investigators could not agree on how the defendant would transfer the evidence contained on his phone did the investigators seize his phone to preserve the evidence and obtain a search warrant, Gomez writes. She cites a case that temporary seizure supported by probable cause and, quote, designed to prevent the loss of evidence while police obtain a warrant is usually lawful. Gomez also cited a specific cell phone related case, Riley v. California, in which courts found officers can seize and secure cell phones to prevent destruction of evidence while seeking a warrant. The same case found, quote, to prevent destruction of evidence via remote wiping, officers can power the phone off or disconnect the cell phone from the internet. That's exactly what JCPD officers were attempting to do, Gomez wrote, when they took his phone. Their discovery that it had been wiped did not result in their clicking on any folders or apps. The investigators certainly had reasonable concerns about evidence potentially being destroyed, and those concerns were confirmed when evidence on the phone was destroyed, Gomez wrote. Finally, Gomez argues that Johnson City Police Department operated in good faith when it seized Williams' safe, and that its second search warrant contained ample evidence to support probable cause that evidence of a crime was contained within the gun safe. Judge Corker issued an order Monday scheduling a hearing on the motion to suppress. So that's set for August 10th, and then the deadline for a plea would be August 22nd. So could be important in taking a plea, but we know he's not going to take the plea deal. And the jury trial is scheduled for September 12th, and we know that we're in July and the trial hasn't started yet. So then on August 9th, we see a new charge added that Sean Williams tried to escape jail in July. So he was already facing the possession, felon in possession of ammunition where he could face up to 10 years. But now a superseding indictment was filed in federal court because he tried to escape. So, on or about July 23rd, 2023, Williams did knowingly attempt to escape from custody in the Washington County Detention Center. So, at this point in time, he's now facing the possession and this attempted escape charge. So, he ends up pleading not guilty to this escape, but this extra charge is now going to cause a delay in the federal ammunition case. And so, Michaela Evans was actually at this hearing. You can see she has her cane and she has a seat cushion. And this here is identified as, on the right, Thomas Sparks. And then they just list this guy as another officer. Again, so we have some details here that Sean Williams' attorney asks for more time to review this case around the escape charge. He hasn't been able to review the discovery yet. And then Prosecutor Gomez doesn't object to this. So Corker ends up rescheduling some dates here. So new motion hearing on October 3rd for the motion to suppress in the ammunition case, and then a September 22nd deadline for motions over the new escape count. And now Williams will have until October 19th to enter a plea. And we also get this updated photo of Sean Williams. And Michaela Evans notes that she started crying during the hearing as soon as Sean Williams started talking, even though she at first thought that she'd be okay. Williams did a bit of talking out of turn during the first hearing. So he had said that, yes, I want Judge Wyrick to read this indictment. As she began reading through the ammunition count, Williams began to talk. Wyrick cut him off, and he said he'd only needed her to read the second count and was just trying to help you out. Wyrick tersely informed him he needed to remain quiet through her reading. From there, he only answered yes. Both times he was asked whether he understood what was alleged against him in a single count. And this article ends in an interesting way based on what the next article is going to say. So, News Channel 11 asks Evans how it felt to know that her near-death fall proved to be the first domino in Williams' still expanding case. She says it makes me proud, actually, adding that she hopes Gomez and the federal government will successfully defend the search warrant. Hopefully, whatever they collected or gathered is sufficient enough evidence to continue the ball rolling, and I hope nobody throws anything out. Now, what do we have next? What do we have next? And, this is going to be some serious stuff we're talking about, so just to give you that heads up here. The ball is rolling. There's this warrant. Sean Williams' defense attorney wants it gone because they're arguing it was improperly seized. Prosecutor Gomez is responding by saying, hey, there is some case law that in this type of situation, when it comes to preserving evidence, this type of seizure can be lawful. So they're fighting the motion to suppress, filed by Sean Williams' defense attorney. Well, on August 22nd, we get this. Computer files show 52 Sean Williams alleged R-words. Western Carolina University police found devices with images and video of more than 50 R-words allegedly committed by Sean Williams in Johnson City after arresting him in late April. A search warrant affidavit filed in Jonesboro, Tennessee states, That warrant sought access to additional phones and computers that the Johnson City Police Department has held since seizing them in September 2020 during an investigation into a woman's near fatal fall from Williams' fifth story downtown Johnson City apartment. Two other warrants filed in June and July sought Williams' DNA and other physical evidence, citing probable cause that he committed two specific Rs, both allegedly recorded in video or images in November 2019 and November 2020. And guys, when I came across this is what made me go all the way back to the beginning and start with part one. In the affidavit here, your affiant has identified approximately 52 female victims, which are depicted in digital images or videos being essayed by Williams. These assaults all appear to occur while the female victims were in an obvious state of unconsciousness and are identifiable as having occurred at Williams' apartment, and they blur the address, in Tennessee within Washington County. And YouTube's gonna hate me. These images depict, and they're blurred, but it looks like words YouTube hate, so anal, vaginal, and oral. And I'm not sure if this is essays. This looks like it might say essays based on the wording. By digital, and it looks like maybe genital by a male. And the investigator here, the affiant here, is Mike Little. He is a first judicial district criminal investigator, and he's using this to request a search warrant for Sean Williams' computer and digital storage devices. The video or photo evidence was on the North Carolina devices that showed essay not just on those two women, but on three others who filed essay complaints with JCPD between June and November 2020, according to the affidavit. So again, for the sake of this lawsuit, this is not good for Johnson City, because these women had tried to report, and they're saying that Johnson City Police Department didn't investigate, they didn't protect them. So Little's affidavit supporting a search warrant requested access to 4 phones, 4 computers, and 3 memory cards of Williams that the JCPD seized around September 23, 2020. 2 additional affidavits requested permission to collect DNA and other physical information from Williams, who has been jailed since April 29th for possible use in 2 specific R-word prosecutions. Little's affidavit also argued probable cause that Williams allegedly essayed at least 2 children at his apartment. 2 separate federal lawsuits claim the 51-year-old Williams, who is currently jailed and facing federal charges, was a serial rapist. Little's affidavit also says that, hey, since Williams seems to have been doing this for a long time, the likelihood of additional images being stored on other digital devices belonging to Williams is highly likely, if not probable. In other words, there's reason. They're giving the basis here for this warrant. This is why we want this warrant. This is why we think we're likely to find what we think we're going to find. And as a reminder, to date, Williams has not been charged with any essay charges. The affidavit suggests there's probable cause the devices in Johnson City show evidence of aggravated rape of a child, sexual exploitation of a minor, and unlawful photography in violation of privacy. Those computers, phones, and memory cards, Little wrote, have been in the JCPD's possession since September 2020. That's when JCPD executed its own search warrant as it investigated Michaela Edwards' near fatal fall from Williams' 5th floor apartment window on Spring Street, downtown. The North Carolina files are alleged to include at least 2 series of digital images showing Williams sexually abusing an infant boy less than a year old and a girl less than 8 years old. That incident and JCPD's handling of it precipitated an ongoing string of events that included the April 2021 federal indictment of Williams for being a felon in possession of ammunition. The ammunition was discovered in Williams' safe during the Evans investigation. Guys, Dahl wanted this investigation, and she was allegedly fired. She's claiming that she was fired for being a whistleblower because she tried to push for this investigation. And even though they approved a very narrow warrant in relation to possible possession, we looked at in part 1 and part 2 how they botched their attempt to serve that warrant when they went to his apartment and stood outside of it for 45 minutes when he ends up going out like the fire escape out the back. And maybe on one hand, there really wasn't enough for them to approve the expanded scope of what Kateri Dahl was asking for. But if they hadn't botched the warrant for the possession, He was a fugitive for like 2 years, wanted on the possession charge. If they had gotten him for that, the things that occurred after that could have been prevented. But they didn't end up arresting him really until in North Carolina he was found asleep in a parking lot. And we've discussed that, but it's summarized again here. While allegations of Williams' sexual predation first surfaced publicly in former U.S. Attorney Kat Dahl's June 2022 federal lawsuit, it appears to have taken a part-time campus police officer's chance encounter with Williams on the banks of the Tuckasegee River in Kaloe, North Carolina, to blow the case open. And this is again, we saw this mugshot when we talked about his arrest in North Carolina on April 29th. None of the multiple reports by women to JCPD had yielded a charge. And we've looked at that report now. In retrospect, we can apply that report from DLG, that audit. And we've got some explanations why. It's incomplete investigations. We don't even try to talk to the suspects 66% of the time. Investigations are flawed and inaccurate. Victims are discouraged from giving statements or pursuing prosecution. So none of the multiple reports by women to JCPD had yielded a charge at that time. Dahl, who pressed JCPD to more assertively investigate those allegations, eventually settled for the ammunition possession warrant. Officers attempted to serve the federal warrant on Williams at his home on May 5th, 2021, but were unsuccessful. So he ends up a fugitive for nearly 2 years before this university officer, Charles Gooden, arrests him during a routine patrol of a Riverside parking area. And now News Channel 12 is saying, well, look, we reported on the discovery of the substances, 12 ounces of cocaine, 14 ounces of methamphetamine, but police also seized about $1,000 in cash and multiple electronic devices and digital storage devices. Those included 2 thumb drives taped together in fashion so that the USB ends were opposing and both drives could be used. So I've got two of the same chopsticks here. Essentially what they're saying is if these were the devices, the part that would stick into a device to be read was ready to go. You just flip and then replug it in. As they investigated suspected drug trafficking due to the large amount of drugs and cash Williams had on him, the investigators obtained a search warrant for the devices. Once North Carolina police found evidence of apparent Johnson City essays and child pornography, they alerted Tennessee authorities. Little and FBI Special Agent Paul Durant traveled to North Carolina, where WCU Police Chief Stephen Lillard reviewed some of the discovered images and files with Little and Durant. One of the thumb drives allegedly contained more than 5,000 downloaded images of CP. Because of its relevance to what Little called ongoing JCPD investigations, the material on the thumb drives was downloaded by Lillard for review by Little and JCPD investigator Thomas Sparks. Sparks led the investigation after Evans fell, which ultimately concluded no foul play. We also get some information on sentencing in Tennessee. So, at the state level, aggravated rape is punishable by 15 to 60 years in prison. Aggravated rape of a child is punishable by life in prison without the possibility of parole. Sexual exploitation of a minor can carry a 2 to 12-year prison sentence, and a person can be charged for each individual image. Now, the day after what we just read, Jeff Keeling and John Janko come in with some great additional details. So while Dahl was working on this case involving the federal ammunition charge back in 2020, she began to learn about the alleged rape allegations against Williams. So she started to request documents and other material from the Johnson City Police Department. By doing that, she hoped that she could broaden the investigation to more than just the ammo. Jeff and John are looking at these affidavits, and among the requests for these different documentations, these other materials, was some of the very same material that hadn't been reviewed as of late May 2023. So from fall of 2020, Kat starts asking for these things. And we know that they still were not looked at in May of 2023. So in early November of 2020, Dahl began seeking a federal search warrant for Williams' computer and a phone SIM card, but Johnson City officers did not provide needed documentation until mid-January 2021. A paragraph in the suit reads, "By that point, the evidence for the probable cause affidavit was too old and stale to meet federal requirements for obtaining a search warrant." Case files from investigator Thomas Sparks, who handled the Evans investigation, confirmed that on January 12, 2021 at 11:50 p.m., quote, "I sent the search warrant for Apple computer and SD cards to Kat Dahl. 8 days later, Sparks wrote, quote, "The investigation into this case didn't reveal any criminal activity." And then I love the way this article's written because the very next line is a trail of grape allegations, in that in his recent affidavit conclusion, Little, a different investigator than Sparks, asserted that Williams has participated in the various sexual-based offenses for an ongoing and sustained time period. So we get this right after this sentence, quoting Sparks, saying that the investigation into the case didn't reveal any criminal activity. Oh, well, he's been participating in these offenses for an ongoing and sustained time period. But we also get this detail here that in Little's affidavit that of the 28,713 data files he reviewed, he identified in excess of 8,000 files depicting sexually based criminal offenses. Now we have a complainant from 2019 and now two 2020 complainants appearing in this video and pictorial evidence, being essayed and apparently in the state of unconsciousness. Investigators have now filed successful search warrant affidavits to collect his DNA and other physical evidence from Williams. And we've also got new details from the 2019 case. So, a woman told police she had gone to Williams' apartment after consuming a number of drinks at a restaurant. She said she shared a beer with Williams and that he then took her to his bedroom, and she started feeling extremely lethargic. After waking up around 10:30 the next morning, she wasn't sure if Williams had sex with her, but she knew she hadn't consented. Because she was feeling odd, she went to an urgent care clinic to get tested for drugs. The screen showed benzos, despite the woman saying she doesn't use any drugs. The woman then had a sexual assault kit completed at a Johnson City medical center. That's the same testing kit, guys, SANE. And that was sent to the Tennessee Bureau of Investigation. It came back in late March 2021, but there's no further record of investigation by JCPD. According to the affidavit for Williams' DNA sample filed on June 1st, 2023 by JCPD's Sparks, the North Carolina data includes a folder with the alleged victim's name on it. So there's a folder with this person, the 2019 complainant. There is a folder with her name on it on these devices. The woman, identified as the alleged victim, appears to be unconscious, and a male can be seen completing sexual acts on her. Sparks' request adds that the tattoos on the man's arm and hand are consistent with the tattoos that Sean Williams has. Barely a year after that incident, and 2 months after the Evans investigation began, another woman reported an alleged essay by Williams at his apartment. In between, at least 2 other women had also reported alleged essays. The woman who placed the November 24th, 2020 report told JCPD she'd been an overnight guest at Williams' apartment and woke up at 8:30 that morning to discover Williams was allegedly in the act of essaying her. After managing to escape, she drove to the Johnson City FBI office, where agents told her to report to JCPD. She made a report and underwent an essay examination at Johnson City Medical Center. As in the case a year earlier, Johnson City Police Department sent a sexual assault kit to the Tennessee Bureau of Investigation. When it came back on July 14th, 2021, it indicated that a male DNA profile had been discovered on the submitted material. The details on the November 2020 incident are contained in another search warrant affidavit, this one filed in July by Little, in which Little asserts probable cause that Williams is in possession of evidence, DNA, of grape. Like Sparks' affidavit, Little points to video or photographic evidence from North Carolina files. Little found a folder with that victim's and another woman's name on it. Inside the folder, Little found numerous photographs of 2 female subjects who were in an obvious state of unconsciousness being essayed by Sean Williams. Little writes that he is able to positively identify the woman who made the police report in November 2020, and that he found 2 additional folders with photographs of her being allegedly essayed by Williams. And then we have another statement from Ben Putland that says, "It's hard for us to imagine that there isn't a fair number of people who knew what was going on for a long time, and were either intentionally or accidentally or negligently failing to do their job." And I agree. And now feels like the promises made after this DLG audit, that they now seem a bit hollow. Putland says he wants the city commission to put out what he called a non-waffling statement. He said he believes the commission's approach to the Dahl Williams case has been to be a little passive and non-committal. Quote, "There's no version in which they should not make a hardline stance about this and say, we're going to do something and here's what. We're going to try to do this now or very soon," he said. And I agree. So on August 25th, we get a response from Johnson City to the Jane Doe lawsuit. And likewise, we also have another media briefing with Kathy Ball. Both of those things are linked in the description of this video. And what's interesting is there are 14 defenses issued here. And on one hand, that's the attorney's job, right? To put forth legal defenses to the plaintiff's complaints. But on the flip side, we had Kathy Ball in the previous media briefing. Hey, no excuses. We're going to do something. So when you see 14 defenses being issued against Jane Does that are saying you didn't do something right, you didn't do enough to protect us, this type of response in the civil action contradicts the media briefing statements. And of these 14 listed defenses, one of them is that the plaintiffs are time barred by the state statute of limitations, that the city was not alleged to be an educational institute capable of violating Title IX, and the conduct of Jane Does puts them at comparative fault. The answer also denies several of the claims made throughout the Jane Doe lawsuit and acknowledges others in part. So Kathy Ball tries to get ahead of my criticism, and I'm certainly the criticism others will bring forward. Quote, "We hired attorneys to be able to defend us, and under their obligation, their responsibility, and their oath, they are required to try to provide the best defense that they can to the city." Which that's true. I'm just saying it's conflicting from a media PR perspective versus legal defense strategy. Ball also says that the city has not been served with the lawsuit, which is unusual. She says that we've taken a very proactive approach on behalf of trying to expedite the process, the legal process for the victims, for the plaintiffs, for everybody concerned in providing an answer to this lawsuit. And now one of the defenses is at odds with the stance that Kathy Ball took in a previous media briefing. And it seems like she's trying to get ahead of that criticism here. She had previously stated she wanted the environment to be more comfortable and accepting and welcoming of victims that wanted to come forward. But one of the defenses that these attorneys are using in their defense of the state against the plaintiff Jane Does is that their own behavior places comparative fault on the victims, on the Jane Does. So let's watch this and let me know what you think about this statement here, this acknowledgement here from Kathy Ball.
There are allegations that are made by Jane Does, and in that factual information that they provide, it indicates that they consumed and partook of illegal drugs during the course of that time period with the visit, and that is contained within the information that they provided in the lawsuit. So as part of the defense under a civil lawsuit, our attorneys are using comparative fault as a fact that is included within that. We recognize that doesn't, in and of itself, saying that they went to the apartments, they partook of illegal drugs. Admittedly, within the complaint, they have acknowledged this. Our attorneys in the civil lawsuit have listed that. If they do not list that, then throughout this lawsuit, they can never use that as a legitimate defense against this civil lawsuit. It's important for us to acknowledge that and also support the fact that our attorneys are responsible, obligated from an ethical standpoint to do that. And we're responsible as public servants to be able to take that recommendation and to be able to assert that within our claim. However, I want to point out very clearly, and it is really for us, we want to make sure the public understands this. There's a civil case against the city. There's the way our police department handles criminal cases. And in criminal cases, there is never any good reason that anybody deserves to be raped. And when people come forward and they have been raped or sexually assaulted, that is never a factor in terms of the police department investigating that charge without bias toward the person who is coming in, the victim. So that is important to note because it can be very confusing. I don't think by walking out of here today that we're going to clear all of that up. What we have said, we will be transparent of that, and we understand that this is two different sides to a legal system. The criminal side, we are committed to serving the victims with compassion and care. We have great relationship with our district attorney and his office, and we are pursuing sexual assault cases in every way that we should. So I wanted to point that out to you. I wanted to come to you and say that that is in the findings and make the public aware of that information.
So, how do you reconcile that? On one hand, we need to cover our butts, and it's our attorney's fiduciary duty to offer this defense. But at the same time, it's contradictory to our mission and to our own statement that our police department still pursues proper investigations on behalf of victims. They don't place this type of comparative fault at the forefront when trying to decide if a victim's credible. How do you reconcile that? Can you reconcile that? So, in my own opinion, we have briefings where no excuses, we're going to change, we're going to take action, we're going to make sure we fix these things that this audit found were wrong. That's not how victims should be treated. It's not how they should be perceived. But at the same time, we're going to perceive them that way for the sake of our own defense in a civil lawsuit. How do you balance it? And for what it's worth, Kathy Ball is fully aware that what she's doing here is a balancing act. She's trying to explain both, but I'm not sure you can have that explanation hold water on both sides. And remember, we're looking back at August 25th. And shout out to Marie Lee for covering this because I think this is a great thing to have documented here. We've got Kathy Ball saying that the police department investigates without bias. And then we also find out in this interview that First Judicial District Attorney General Steve Finney is going to be taking over the lead on investigating these new essay allegations against Sean Williams. That's no longer going to be Johnson City looking at it.
After Sean Williams was arrested in North Carolina, we began working with the DA. As we move further into it, our chief of police, in conjunction with the DA, agreed that it would be best and most appropriate for the city of Johnson City to not be involved in those investigations for the purpose of making sure the victims felt safe and that there was no thought of harm done to them or any reason that they wouldn't come forward. So I am not able to update you on anything associated with that. I will say we have complete confidence in our DA. We know that they are diligently trying to pursue charges and to do the right thing and to work with victims of Sean Williams.
You said that the DA's office is leading this then, but there was a search warrant filed by the DA's investigator on Monday asking to search those devices. And then the next day, Johnson City Police investigator filed for a search warrant for Sean Williams in DNA. So was there a reason for the timing of that?
So, excuse me. So yes, at that point in time, after Sean Williams was arrested, both the city of Johnson City and the DA's office was notified that he had been arrested in North Carolina and were working in conjunction with each other at that point in time. So the search warrants were done with them working together in doing that. As the investigation moved further along, for the integrity of the investigation, there was a decision made after that date that the city of Johnson City Police Department would not be involved in that investigation.
Are you able to tell us when that decision was made regarding JCPD's scaling back their involvement in that?
Generally, I would say in July.
Can you speak to, though, when you found out what's allegedly on the thumb drives that North Carolina recovered with the potentially 52 different women that have been victims? Just your thoughts on discovering that the numbers and the allegations and the potential crimes that have been committed.
I will tell you that I don't know that we have done a great job of educating the public in terms of how we get probable cause, how we access information in general. I think we could expand our education knowledge and probably in a lot of places to help folks understand when we have the right to get information, to gather information from someone and what that probable cause looks like. I think that what you saw in the search warrant request for the computers was done after the information was obtained in.
But remember, Kat Dahl was requesting these materials, different materials. And we're finding out that nobody reviewed them. They weren't reviewed until May of 2023. these devices have been held since 2020. So I initially, if you saw my face when she said, we haven't done a good job, I was like, yeah. But now it seems like she's saying we haven't done a good enough job letting people understand why we sat on our hands since 2020.
Eastern Carolina. And so there was more information at that point in time. I was
So
not
we-
here.
So we have more information because North Carolina found it. But now we're hearing from her, and great job on these reporters. It sounded like 3 different voices kind of tag teaming these questions in succession, saying, what was the time frame of this? And we hear, in July the city started phasing back a little bit and letting the DA handle it. And we have full faith in the DA. And, right when we find that there's stuff on these devices that we sat on our hands about, now we want to hand it over completely to the DA because we've got this lawsuit against us saying that we didn't do our job. And now we're going to rush to try to make it look like we're taking ourselves out of this process in light of this lawsuit that we just filed a response for. So great job on those reporters for trying to pin down the timeline here. And then 4 days, maybe 3 days after this briefing, on August 29th, we see that we get a small update that Sean Williams, North Carolina drug charges are now officially transferred to the federal court. And then also on August 29th, we get an update from Jeff Keeling that this Jane Doe lawsuit, has now been amended to include claims that JCPD knew of Williams' sex trafficking. Attorneys for 9 Jane Doe plaintiffs who claim to have been raped by Williams submitted the amendment and a motion that it be accepted on Saturday in U.S. Federal District Court. The new allegations claim that Johnson City Police Department officers obstructed justice and, for a time, prevented investigation into what the suit alleges was sex trafficking by Williams. And at this time, News Channel 11 can't confirm if Williams is under federal investigation for this trafficking. But the city of Johnson flatly denied the allegations of JCPD complicity in any sex trafficking. In exchange for turning a blind eye, JCPD officers seized hundreds of thousands of dollars in cash from Williams, all while refusing to take meaningful steps to protect women and children in Johnson City and to stop his known sexually predatory behavior. So here we are getting not just allegations that the police were complicit, but that there was a bit of quid pro quo going on, some money exchanging hands through, at this point, seizure of assets, and doing so in exchange for turning a blind eye. The amendment claims officers knowingly failed to investigate Williams' crimes against women, that they failed to refer charges for prosecution, and that they intimidated and dissuaded plaintiffs from pursuing criminal charges. It says Detective Thomas Sparks knowingly made false statements to plaintiffs in what amounted to obstruction of a criminal investigation, and that Sparks and Justin Jenkins, a newly named defendant, conspired with Williams to destroy evidence, including digital evidence, which showed Williams raping unconscious women who he had drugged. All those alleged actions, the amendment claims in one of the 2 new counts, displayed an entire want of care and a conscious and depraved indifference to the consequence of their conduct. And the city of Johnson says that they will respond in a timely manner. They also offered a short but strongly worded statement. The city did not seize any money from Sean Williams. To claim that the Johnson City Police Department was complicit in any sex trafficking venture or that its officers benefited financially from such abhorrent activity is specious, frivolous, and has been asserted by the plaintiffs without any factual basis whatsoever. The amendment adds 2 new federal counts against the JCPD and several individual officers to the 6 previous counts: sex trafficking and obstruction of enforcement of sex trafficking. As evidence of Williams' involvement in sex trafficking, it cites a purported federal investigation into sex trafficking launched in November 2022. News Channel 11, and again, this is August 2023 that this article was written, submitted questions surrounding the purported investigation to the U.S. Department of Justice on Tuesday afternoon. A spokesperson responded late Tuesday afternoon with an email saying the DOJ is declining comment. The evidence the FBI collected in the sex trafficking investigation proved to be overwhelming, including the discovery of images of Williams sexually assaulting unconscious women, including several plaintiffs in this case, the amended complaint now reads. The first new count alleges JCPD officers named in the suit, including a newly named defendant, investigator Justin Jenkins, knew multiple women had reported Williams for sex acts, and that Williams used co-conspirators to recruit and obtain women in exchange for things of value. It claims that instead of arresting Williams and pursuing charges against him, officers knowingly and corruptly mishandled women's rape reports in exchange for seized narcotics assets, all in furtherance of the sex trafficking venture. The second new count in the amended complaint cites 18 U.S.C. 1591d, which reads, "Whoever obstructs, attempts to obstruct, or in any way interferes with or prevents the enforcement of this section shall be fined under this title, imprisoned for a term not to exceed 25 years or both." The allegation of a cash seizure comes from search warrants executed by Sparks in September of 2020, after a woman named Michaela Edwards fell from Williams' fifth-story window. Included among items he applied to seize in a September 23, 2020 warrant to search Williams' safe was any currency found in it, the Doe Amendment states. There were no facts stated in Detective Sparks' warrants which connected any currency with the offense under investigation, the attempted homicide of Evans. The complaint says, "To date, it is unknown exactly how much currency JCPD seized from Williams based on the September 23, 2020 search warrant." And then the amended complaint also incorporates significant portions of an outside audit of JCPD completed by Dahl Law Group. They quote a specific finding from the report that says, "Our review revealed instances where JCPD likely would have obtained statements and facts to support a prosecution if they had used the investigative tactics known to be effective and essential in sexual assault investigations, especially investigations of non-stranger sexual assault," the suit says, quoting page 14 of the DLG report. A new paragraph references Kat Dahl's suit in which the former prosecutor claims she pressed the police department to broaden its investigation of Williams based on the substantial evidence of the more serious charges, including the conduct of drugging and raping women. The amendment points to what it claims was a conspiracy by Williams and others to recruit, entice, obtain, transport, and maintain women who were drugged and forced to engage in sex accounts, on account of which something of value was exchanged. Those alleged activities, it claims, constituted sex trafficking violations. The amended Doe complaint points to the DLG report in a claim that reports and documentation concerning the sexual assault investigations were missing or unidentified because JCPD failed to initiate an internal affairs investigation in response to the allegations of police department corruption in the Dahl complaint. The DLG report does say that after it referred the allegations of police corruption to the DA's office and no outside investigation was ordered, the department should have moved forward with an internal investigation to address the misconduct allegations. It goes on to say that since the DA's response September 1st, 2022, we have received no information that the police department is conducting an internal investigation. And this is important because this investigation could have assisted the DLG in locating or identifying documents specific to the JCPD's investigation of sexual-related cases that were not discovered during the audit. So we are missing this because we can't examine them. If these things are missing, we can't look at them and we can't tell you, hey, something funny is going on here. It's absent. We can't make a finding on it. And as such, the amended Doe complaint states that there are now documents that cannot be located or identified relating to the sexual assault investigations of Mr. Williams, specifically. And then on September 1st, and I think this is a pretty big deal too, this is why it can be important to have advocates. So the attorneys for the Jane Doe plaintiffs raise issue with the courts about Johnson City's extrajudicial statements. So statements made outside of court. They want the judge to prevent further Johnson City statements as to their character or credibility. So this is largely referring to that bit we just looked at in that recent briefing where she says, look, the plaintiffs, the Jane Does, have some comparative fault of their own. They took drugs. So in Friday's motion to enjoin extrajudicial conduct, the plaintiffs allege that Dahl, among other things, made misstatements of fact that stated that all plaintiffs in this matter participated in taking drugs prior to their sexual assaults. In a memorandum supporting the motion, the Jane Doe attorneys wrote that they're seeking a narrowly tailored order enjoining any further public extrajudicial statements by Dahl and any other representative of Johnson City which are misleading and or factually inaccurate. And this is important too because you don't want to ask a judge for broad-ranging, you can't say anything, stop speaking in public. That's not likely to be granted, especially without cause or basis. But they're making this specific request that, you made these statements about comparative fault, stating that all the plaintiffs participated in this. Don't make those types of misleading or factually inaccurate statements. Judge, please order this. And the city responds to News Channel 11's request for comment, saying that the city disagrees with the plaintiffs' limited, selected, and out-of-context characterizations of the information City Manager Dahl relayed to the public on August 25th. The public can listen to the full press briefing and decide for themselves the accuracy of the plaintiff's latest accusations. Now, this is extremely interesting because in the other media briefings, we've had Kathy Ball say, wait for things to come out in court. There's a process here. Be patient, public. Please be patient. But now, in this email, the city, the spokesperson saying, the public can go listen to our briefing, the city's briefing, and decide the accuracy of the plaintiff's accusations based on our briefing. Use our briefing to determine the accuracy of what the plaintiffs are alleging. I don't think that's good. I don't agree with that. And furthermore, this motion for the injunction alleges that Ball's statements about the alleged victims had the effect of intimidating plaintiffs and disparaging them to the public by implying that they were drug addicts. And we're going to see this phrase that we've heard before. Her statements will also likely have a chilling effect on the dozens of other survivors of Williams who have not yet felt safe to come forward and who may be witnesses in this case. Ball didn't actually use the word or phrase drug addicts at any point during the news conference, and did make several references to wanting victims feel safe coming forward. And at this point in time, Williams has still not been charged with anything relating to SA. On September 8th, there's another Jane Doe that comes forward, Jane Doe 10. And attorneys in this Jane Doe lawsuit against Johnson City want to broaden their complaint to a class action that would include at least 2 classes. Now, this Jane Doe is the first who claims to be a victim of someone other than former downtown businessman and alleged serial rapist Sean Williams. Jane Doe 10 lives in a neighboring state and was allegedly sexually assaulted in November 2021 when she was 17, while on a visit to family friends in Johnson City. Jane Doe 10's mother learned August 25th about the allegations that Johnson City Police Department had mishandled sexual assault cases. That's when she saw the News Channel 11 exclusive story about North Carolina police's discovery of images showing Williams essayed more than 50 different women in his downtown Johnson City apartment. Jane Doe 10 would join alleged Williams victims Jane Does 2, 5, and 7 in a so-called reporter survivor class, constituting all women, including minors, who reported SA or trafficking by any person to Johnson City Police Department from January 1st, 2018 to April 25th, 2023. Those 4 all have police reports or investigations linked to their cases, though no charges were ever filed in any of them. The other class listed in Friday's amended complaint, the conspiracy survivor class, includes anyone sexually abused, drugged, or trafficked by Sean Williams, or by an alleged accomplice named in the suit. The conspiracy reference is to an alleged conspiracy in which certain JCPD officers allowed Williams to allegedly drug and rape dozens of women in his downtown apartment in exchange for financial benefits. The proposed class action, if approved, will bring a third law group into plaintiff's complaint. They're currently represented by Vanessa Baird Jones, the co-founder of Advocates for Survivors of Abuse, and 3 attorneys from Brentwood-based HMC Civil Rights Law. The class action attorneys requesting admission to the case is Elizabeth Kramer of San Francisco-based Erickson Kramer Osborne, which specializes in SA and cryptocurrency-related class action suits. Now more about Jane Doe 10. The latest entrant to the case cites many of the same claims about inadequate policing and investigating that are claimed by the alleged Williams victims. Among them are alleged failure to collect an important piece of evidence, failure to interview the suspect, and bringing up Jane Doe 10's past as a possible impediment to successful prosecution. Jane Doe 10 was on a trip to Johnson City for Thanksgiving week in 2021, where she planned to care for a girl she regularly babysat and spend the holiday with the girl's family, who was friends with her family. The suit claims that at a point during the visit, Jane Doe 10 was with the young girl, the girl's grandfather, and his son-in-law or other children. At a certain point, the younger man approached Jane Doe 10 when she was alone in the kitchen and allegedly groped her for several minutes through her clothing after she initially froze in shock, the complaint says. The motion also states that since the June filing, additional survivors have come forward and expressed a desire to be involved in the lawsuit, either as a class representative or as unnamed class members. And the attorneys also want an option to modify the classes, either to expand the time period or to add additional subclasses to the suit. And then on September 13th, we finally have Sean Williams indicted for CP production. Guys, we are going to get into this in part 5. I'm trying to break this up in a way that's a bit more digestible, and we're going to kind of shift away from the civil actions and towards criminal actions now that we're getting these indictments. So I think this is a good part to break. So I'm not a producer by any means. I'm just trying to help bring a light to this story. And my gut's telling me this is where we should break 4, come back for 5. So let me know your thoughts on the civil side of everything so far. What do you think about these briefings by Kathy Ball on behalf of the city of Johnson City? What do you think about this timeline of, oh, we're going to turn this investigation over and then boom, in like a matter of a couple weeks, we're getting indictments finally? And zooming out to the main theme, what do you think about the likelihood, the possibility, the existence of police departments that could conspire to suppress certain crimes this way? What do you think when you hear, well, certainly someone would have been charged if they were guilty of something, or if there was evidence there, if there was proof there, but clearly the investigation didn't find anything? How much faith can you place in the lack of indictment, as meaning someone was either making a false accusation, or on the flip side, that the person accused is actually not guilty? Because when we have stuff going on like this, when the integrity of the process is severely lacking, we've got to question the confidence in the outcomes. So again, food for thought for days, and maybe after all these parts are published, we'll do one big live stream where we can talk about everything. So again, a ton of stuff we can talk about. You guys let me know your thoughts in the comments. We'll be back for part 5, and you guys all take care until next time. Bye-bye.